brown bag beat bite session for today, COVID-19 in 2021, guiding your association through the pandemic endgame. We appreciate you joining us. That lovely lady was Miss Melissa Francis. She is an associate attorney out of our Plymouth office and will be hosting you with her wonderful hosting skills on Zoom today. She's already given you the housekeeping issues, so I'm going to push forward on that. I am Stacia Miller. I'm an associate attorney out of the Mount Clemens office, and I will be hosting you on Facebook Live. If you're joining me on Facebook, feel free to introduce yourselves and ask any questions you have in the comments section. And the questions on Zoom should go in chat. Melissa will give Mr. Fioritto your questions from Zoom. I will give Mr. Fioritto your questions from Facebook. Our wonderful host today is Mr. Gregory J. Fioritto. He is a partner out of our Plymouth office, and he is here today to inject you with some COVID-19 knowledge. Mr. Fioritto specializes in document amendments, rental cap issues, fair housing compliance, and COVID-19 issues, and he is the co-chairperson of the Michigan Community Association Institute's Legislative Action Committee. Whew, I'm out of breath now. Mr. Fioritto will be discussing governance, reopening, enforcement, liability, privacy, and the financial impact of COVID-19 in 2021. So let's give him a feverish welcome and make him go viral. Mr. Fioritto, take it away, sir.
Thank you very much, Melissa and Stacia, for your wonderful, colorful introductions. Interesting as always. Thanks everybody for coming today. And today we're going to talk about COVID-19 again, but hopefully a little bit of a different take today. You know, we're hopefully coming through the end game to the end of this pandemic in 2021. So we're going to talk about how things have changed, how we can expect things to be different this year than last year. A little bit about myself before we get started. I am a partner with our firm, Zelmansky, Danner, and Fioritto. Our main office is in Plymouth, but we have another office in Mount Clemens as well. I've been doing community association law virtually my whole career. Since 2003 with this firm. I passed the bar in 2000. I'm also a University of Michigan grad twice over, so go blue. And hopefully we have a few Wolverines in the chat, although I probably just alienated half of you. Also, I thank you very much for joining us on today's inauguration day. Since you're all here and not watching the inauguration, perhaps I can assume that you guys are all Republicans, or no. Stacia said I should not assume that, so perhaps I won't. There's a go blue. But thanks a lot for joining us today. So let's move on. Here we are with our topics for today, and it kind of boils down to 6 categories as far as the issues that we keep seeing as attorneys dealing with COVID since March of last year. Number 1, governance, the big question. Meetings, can we have our meetings? How do we have our meetings? Number 2, opening and reopening of facilities and our common elements. What are the risks? What are the issues that go along with that? Number 3, enforcement of your governing documents. You know, can we still enforce our bylaws even though, you know, we're in the middle of this pandemic? You know, are they still valid? Should we still enforce them? Number 4, liability issues. This is a big one. We're going to talk about a difference today. That's the new law that came into play to make things different from last year to protect your association from liability from COVID claims. Number 5, privacy considerations. You know, can you reveal information about a co-owner who has COVID? And number 6, financial impact. You know, how is this affecting your association's collections? How is it affecting your expenses? So those are the main 6 categories that I'm going to talk about in the hour we have today. And I want to encourage you also to put your questions and comments in the chat. If you want to share information with the other attendees, that's great, about your association and what you experienced. And as my trusty, rusty associate attorneys, Stacia and Melissa, have said, you know, they'll get to your comments in between slides, and I want to make this an interactive presentation. So please, by all means, submit your questions. There is no stupid questions. There are no stupid questions. Please feel free to do that. So with that said, I want to go out to our the first topic today, which is really just laying out the background of where we're at with COVID-19. Where do we stand today? You know, January 20th, 2021. We have a new president, obviously, but what else is going on? What's the state of affairs? The vaccine. So as you know, they're rolling out the vaccine. They've been staging this. So you will get the vaccine depending on what group you're in. They're already moved through group 1A, and I think now we're getting close, or have moved into group B, 1B. I'm not in either of these groups. I'm in more like group 76 or something. I don't know. I'm down the list. I'm far down the list. So this is kind of, obviously everybody's been waiting for this, and it hasn't been going, super smoothly. It's, all things considered, it's kind of been slow, a little slower than everybody had hoped. But this is the schedule. So next slide, please. Melissa. All right, thank you. So these are the next groups. As you move through it, as we move through the year, we could expect vaccine to open up to other groups. As you can see, I'm not going to get my vaccine until maybe, I guess, group 3, mid-August, September. And you can, look at what category you fall into these other groups. I don't know what group Stacia and Melissa are in, if maybe they beat my group designation status, but hopefully by like the end of the summer, we can all expect to be either have gotten or be getting the vaccine to, hopefully bring an end to this situation. Next slide, please. So here we have a young Elon Musk looking up at the sky wistfully, thinking about a time before COVID. Actually, I don't know if that's Elon Musk. It kind of looks like Elon Musk. I can't really tell with the mask. It could be anybody under there. But, his thought here is he's thinking, 80% of people recover without needing treatment. Okay, but when can we expect herd immunity? That's the big question. When can we stop wearing these darn masks? And when can we expect this to be over? Well, it's important for associations to think about these things. That's why I'm kind of laying this out, because this will kind of factor into our considerations for our associations and for our board members later in the year as we go through this. But next slide, please. So this is our like red hot map, glowing red. If you're in the red, it's not good. But looking at our daily case numbers, obviously California's been hit hard. Michigan's doing a little better lately, although we were hit hard at the beginning, and this is probably going to change as we go into spring. Springtime, when that happened last year, COVID died down, and then it picked up in the warmer states. So maybe we'll see that. But clearly, a lot of states getting hit hard right now. Next slide, please. So here are our grim statistics. I just wanted to put that out there just to kind of get a snapshot where we are. This is as of roughly today in January, and as you can see, the deaths are almost 400,000 in the country, and then we have the Michigan stats as well. What we're looking at there, it's been tough, and we're still in the middle of it. It's not. I'm not saying that the end game is this month, because clearly it's not. But I do think as boards we need to start thinking about how this is going to end and what we can do as it gets to the end. Next slide, please. So, when will things be normal? Well, as I said earlier, probably when we get to herd immunity and when the vaccine's been distributed. Scientifically, that's, when you get to 70% to 90% of the population that have either been vaccinated or had this. As I said earlier, in the vaccine rollout schedule, late, August, September, maybe everybody has had a chance to get the vaccine. And maybe by the end of this year, so maybe by December, we can look at things finally being close to what they were. So think about that. I mean, that's almost a whole nother year of going through this. So again, it's not over, and we're still going to have to do some things in 2021 that we did in 2020, but there are going to be some differences. I'm going to point those out. Next slide, please. So, okay, here's like the percentage of people who have actually been vaccinated as of roughly, again, today. You're looking at, 4%, and Michigan has roughly the same percentage, 4.2%. So that's a far cry from 70 to 90%. As I said, hopefully this would go a little faster. I think we're hoping, but that's what you're looking at. So we got a lot of work to do for this to really be the solution for us to be done. Next slide, please. And mutations. Excuse me, mutations. What's going to happen if this virus mutates? Is this going to make it spread faster? Well, there is a mutation that's been identified in other countries, and actually it has been found in Michigan as of January 19th. There was at least one case in Washtenaw County. So that's the faster spreading version of COVID-19. I hear that it spreads, the stats are right on the slide, 70% more transmittable. So will that affect things as we go through this year? Will we see more cases in the spring rather than see them decline because of this mutation variant? I don't know, but definitely something to think about and keep an eye on. Next slide, please. All right, so let's talk about the state laws for a minute. Everybody's familiar with Governor Whitmer's executive orders that she started issuing last year. A lot of detail on who was shut down, when you could reopen, and those were all ruled unconstitutional by the Michigan Supreme Court. After all that, the Michigan Supreme Court says, no, Gretchen, you exceeded your powers to declare an emergency, and we're going to nullify all those orders. So that's what the Supreme Court did. But Governor Whitmer didn't miss a beat, and a few days later, we had Robert Gordon signing off on a Michigan Department of Health and Human Services orders, which basically replaced the governor's orders. So orders are back in place. And this is what we're following now as far as the state of Michigan is concerned. It's the MDHHS. Next slide, please. So a word about these orders. What is the effect of these orders? The orders, they do have the effect of law. The local health department where you live has the authority to enforce them, as well as law enforcement officers. They are department representatives under these orders, and they can investigate violations of these orders. If you violate the order, it's a criminal act. It's a misdemeanor, punishable by imprisonment for not more than 6 months, or a fine of not more than $200, or both. And it could also be a civil infraction where you incur a civil fine of up to $1,000 for each violation, or for each day the violation continues. So, there are some teeth to these orders. So you got to think about that. And as an association, it's like, can we expect law enforcement to help us? Can we expect the health department to help us enforce these things? We don't want to be the COVID police, associations, boards would say. So maybe it depends on where you live. I know when this started, a couple counties were kind of backing off and saying they wouldn't enforce the orders, and that was more of a political issue. But they are legally enforceable when you look at what the order actually says. Next slide, please. All right, so I like this little picture. Kind of tells you where we're at right now with COVID. The January 13th MDHHS order, that's the most recent order. And this is a really nice little graphical summary of what is open and what's not open. And, I'll talk a little bit about this in more detail in a minute, but, for associations, you're looking at meetings, right? Association meetings, gatherings, what's the limit on that? Right now, under the January 13th order, the limit is 10 persons for an indoor meeting from no more than 2 households. And the limit on outdoor gatherings, it's a little bit higher. It's 25 persons from no more than 3 households. So those are the ones, as an association, are probably going to be the big ones that you think about that are going to stop you from being able to have a meeting. I know I did a few outdoor meetings, or at least one outdoor meeting last fall, or last summer actually, for an association to try to get around that. And it worked pretty well. We did an association meeting, an annual meeting, in a tent in the parking lot of the association. It was an attached condominium. And that went pretty well. We got it done. They had their election, they had a great turnout. They met quorum and then some. So, but, looking at this order right now, obviously, number one, it's too cold, so you're not going to be going outside. But thinking about, if these orders loosen up over the summer, how are you going to get around these things? Next slide, please. So a little bit more about the actual terms of the order. I just covered the indoor gathering limitation and the outdoor gathering limitation. Masks are now required too. There's a specific section of the order that deals with, you must wear a mask. And if you're hosting an event that's otherwise allowed, you still must make sure that the people there are wearing masks and that they're social distancing. So obviously, if you're on a board of directors and you're having your association meeting in some form later in this year, you're going to have to make sure that you meet those requirements. Next slide, please. All right, so can we, should we? I put this on a lot of slides, you're going to see it, because it's like there's two questions. Number one, the question is for the board, can we do this under the orders? Is it legally permissible? Does it violate any local, county, or state, or federal requirements? Does it comply with CDC requirements? That's can we. Should we is, okay, even though maybe we can do something, should we? Is it a good idea? Even though we can have an indoor meeting, should we, because of other considerations, insurance considerations, liability considerations, if we get sued and our insurance doesn't cover it, we could still be sued even though we did something that wasn't per se illegal. There are a lot of communities last year that decided to have meetings, or not have meetings rather, I'm sorry. And, they could have, but it was like, no, we're just not going to take the risk. We're just not going to take the risk. So that's should we. So going back to the 6 topics that I brought up at the outset of today's presentation and getting into a little more detail, what are these about? Number 1, governance, annual meeting. When can we have it under these orders? If we have it, how do we have to conduct it? And if we didn't have a meeting last year, do we have to have a meeting this year? That's a big one that's going to happen because I know a lot of associations didn't have meetings. Second item, reopening of facilities, especially if you have a pool or a clubhouse. When can we do it? What will be the requirements and standards for doing so? What are the CDC requirements? Got to look into that. Number 3, liability issues. If we have an in-person meeting, what is the liability risk to the association in 2021 compared to 2020? Or if we reopen our pool this year and we didn't open it last year, what are the liability considerations now? Next slide, please. So the other 3 key topics, enforcement. Can we still enforce our bylaws even though there's a state of emergency and a pandemic going on? If we can't, should we? Is it a good idea to go after people for certain violations? If we can, even if we can, is it still a good idea to do it? People park their first responder vehicles in the driveway or in the streets because they have no other place to park it. Should we cite them for violating our parking rules? Is COVID hurting your association financially? Are we having more delinquencies as a result of COVID? Are we experiencing more costs of cleaning and providing personal protection equipment and complying with the CDC requirements? Are those costing our association more money? And then the number 6 is privacy. Can the board tell their community if a member has COVID? And then what about this? When the vaccine becomes more available, can the board or the association ask a co-owner if they've been vaccinated as a condition of using the pool or using other common elements? So those are some of the big issues I think that we're going to see in 2021 and that may have different answers as opposed to last year generally. Next slide, please. All right, so let's get into a little more detail on the meetings issue. This is just a slide that summarizes the Nonprofit Corporation Act, which applies to both condominiums and HOAs. And what this act says is basically, number 1, as far as having a meeting is concerned, you're not supposed to go more than 15 months between your annual meetings. So if any association skipped their meeting last year, they're going to violate this requirement for sure if they don't have a meeting this year. So in my opinion, you're going to have to think really hard, assuming the pandemic is still going on later this year, especially when it warms up. are we going to do the same thing we did last year and cancel our meeting? I think this year it's going to be a significantly higher risk of being sued for that, because people are going to be like, look, we haven't had a new board in 2 years. And, maybe they're going to say, you're just, trying to hold on to power and taking advantage of this pandemic to do that. So you got to think, really hard about that this year, in my opinion, before you skip it again. I think you're probably better off, especially if things get better and the pandemic gets better, you're better off actually trying to have that meeting in some fashion, try to have a virtual meeting, and or let people participate virtually, even if you have an in-person meeting, like a hybrid. So next slide, please. And these are the requirements of the Nonprofit Act that I was talking about a little bit earlier. In the Nonprofit Act, which again governs both condos and HOAs, it does allow you to do these things. Unless your documents prohibit it or restrict it, you can allow people to participate in your meeting by means of remote communication. So you could say, yeah, if you're afraid to come in person, you can Zoom in, okay? You can do that, as long as your documents don't prohibit it. And then you can also, the other part of this statute is you can have a meeting completely by means of remote communication. So like entirely by Zoom, you can do your meeting, and that's legal, as long as your documents don't prohibit it. And most associations' documents they don't even address this, so let alone prohibit it. So you're probably okay to do this if you want to. If you do it, the only thing you should remember is there are 3 requirements you have to meet in order to do it. In the Nonprofit Act, you have to make sure basically that the people who are voting are members in good standing, that they are actually members of your association. And you got to make sure that you give them, reasonable measures need to be implemented to allow people to participate that way. And a record of the vote must be maintained by your association. These are not hard requirements. These are pretty easy requirements to meet, but they are important to remember because they are part of the law. Next slide, please. All right, next topic, liability. What's different in 2021? Well, thank God there is a difference. There's liability protections. This means that as long as you comply as an association with all of the rules, the federal, state, and local rules, then if somebody sues you on a COVID-related claim, you have immunity, okay? So that's great. This law was enacted last October, so it's relatively new. But that's a game changer to me. I mean, that was a huge concern last year was, what if we get sued? What if we reopen our pool and somebody catches COVID and dies and sues the association? So this is really important. This is, and this is like the stuff they were fighting about in Congress as far as liability protections. And I was like thinking about that. I'm like, we already have this in Michigan. We have it now. So it's a great thing. Now, the only thing to remember about this new law is, number one, it's not absolute. Next slide, please. So you have to comply with all of the rules in order to get this immunity. So you still have to follow all the CDC rules about reopening a pool. You still got to follow the county guidelines about reopening your pool. If you can show that you followed all these rules, then you are immune. Okay, so it's not automatic. The other thing to note is that this is retroactive to March of 2020. So even if a claim arose like last July, before this new law was enacted in October, you still would have this immunity if your association can show that you complied with all of those requirements. And further, the law says if there's like a de minimis deviation, like if you did something, you didn't 100% comply, you complied like 95%, like that's not going to make you lose your immunity. So they call that a de minimis deviation. So you could still have immunity even if you didn't do everything 100% perfect, is my point. Next slide, please. So this slide is just, it's not absolute. So think about, what the issue is, what are the risks of opening and not opening, what are the costs you're going to incur in making sure that facility is compliant with the CDC requirements, and weigh those things, and then make your decision in 2021 whether you think it's a good judgment on the part of the board from a cost-benefit perspective. And in making these decisions, I always emphasize rely on your professionals, talk to your professionals, talk to your attorney, talk to your pool experts, talk to whoever is the relevant professional and get their input, because as long as you can prove later that you were acting on the advice of a professional and making your decision, then you should be protected in court. They call that the business judgment rule. So as long as you listen to an expert in doing what you're doing, that should give you protection as a board for being sued for that decision. Next slide, please. Do we have any questions yet, ladies, or? Hello? Any questions, Stacey or Melissa? I'm assuming no, assuming you can hear me. All right, she's shaking her head like this. All right. All right, so lawsuits. What's actually going on out there? I want to talk about this briefly. I tried to find any lawsuits that have been brought against a condo or an HOA involving COVID claims. I could not find any, and I looked. So as far as somebody getting COVID and dying, and then the state suing an association, I have not seen that yet. So I can't say, point to an example of that happening. But there are other types of lawsuits. I did find a couple related to associations. This first one, Palmetto Place in Florida, this was a really interesting one. And I don't advise that you ever do what this board did. Basically, these people contracted COVID, and then the board of directors or the property manager deactivated their key, so they couldn't use the elevator, and they couldn't use the pool, and they couldn't get out of their condo to get to their other unit that they own. So it was like, what are you doing, association? Don't do that. It's not your job to forcibly quarantine people to stop them from using your common elements. So they're being sued for false imprisonment by these co-owners, attorneys, and probably for good reason. So don't do that. Number two, next slide. The Diplomat Condominium Association, and I find that name of the association highly ironic, that they are diplomatic, because they're anything but if you read about this case. But this is a woman who is 80 years old, lived in a high-rise condo unit with two caregivers who were there all the time. And they all contracted COVID together, and they went to the hospital for treatment. But before they came back, their board said, you can't come back. You got COVID. No, you guys can't come back here. So, and they're, so those people sued the association under fair housing, basically saying that they were not provided reasonable accommodation by that association. So again, don't do that. Don't try to keep people from coming back to their units just because they have COVID. You're not the COVID police. I mean, yes, you should be reasonable, you should be prudent, but don't lock people out of their units. It's bad. Next slide, please. All right, number three. So this is not even an association case, but it is the closest case I could find about wrongful death and COVID. And Walmart has actually been sued twice for this so far. And this is one of the cases where Walmart is being sued, and obviously they have deep pockets, so it's not unexpected that this would happen. But a person contracted COVID. They had symptoms of COVID, and they were basically said, you're fine, go back to work. 2 days later, finally they sent him home 2 days later. And then 2 days after that, the person died. So they're saying you did not take adequate precautions, Walmart, in your activities. And this is like an employer-employee scenario. So it's, again, a little bit different than housing. You have, all kinds of other laws that apply, like, workers' comp and things that would be available if you get injured or die on the job. So that's a little bit different. And I know most Michigan associations don't have employees, but if you do, so if you have an employee, this would be an issue for you to think about, as an association. So, but we'll see. We're kind of still, early into this. And so who's to say a year from now we won't see 10 cases against associations. But that's where we're at right now with lawsuits. Next slide, please.
Greg, this is Melissa. There are a few questions that I would like to bring up at this point. The first question is, in respect to electronic meetings, are there any concerns with having an electronic meeting where multiple co-owners aren't able to attend because they do not use an electronic device?
Yeah, I hear that all the time. I know you do, Melissa. I know you do, Stacia. Stacia's probably nodding her head like this. I can't see her, but I know she is. There you go. Okay. So yes, this is a big problem. A lot of associations, or not, I mean, not a lot, but several that I talk to, their boards and their managers are like, look, it's not practical for us. We have older owners. They don't know how to use this, and it would just be a nightmare to try to set it up. And I get that, you know, and I understand that in 2020, totally okay. Like, you can use that, you could go with it. You know, I would say, I mean, it's not the right answer legally, but people did it because just everybody kind of got a freebie in 2020 as far as these types of issues. Like, you don't want to be the co-owner's attorney in 2020 suing the association saying, you got to have a meeting right now. You know, the judge is going to say, what are you talking about? You know, go home. You're being unreasonable. So 2020, that was the deal. 2021, I think it's going to be different. And I think you got to think about this twice, even if you have older owners. You know, I mean, you can only have this excuse play for so long, you know, and say, well, our people don't know how to use smartphones. You know, eventually that will catch up with you. You know, that will seem unreasonable to an outside party, to a judge. You know, it's like, look, you haven't had a meeting in 2 years. You couldn't do something on Zoom. You know, as long as you get a quorum, you're good. You don't have to have 100% of people show up. So, you know, maybe you can make some kind of a joint portal available to people in another location, or have a hybrid meeting where you spread it out, several small groups in different units or something. So I just think that, you know, that might have flown in 2020, but 2021, you can play that same card again. I don't know. I think you're risking, especially if you have a community where you know that people want to get on the board and you know there's some dissent, and you're like, you know, look, these people are going to sue us if we don't have an election because these two people hate these other two people and they want them off the board. So again, your unique status of your community and the unique facts and circumstances of your community is also highly relevant in answering that question. You know, not every community is the same, and not all the risks of every community will be different depending on the facts that are present in that community.
So the next question is, if your association bylaws do prohibit a virtual meeting and require an in-person meeting for there to be debate, what do you do then? There's a contradiction in the bylaws in the Nonprofit Act. What do you do?
Right. That's a tough one. I think, you know, it's rare that, you know, just because your documents say that you should have an annual meeting, or that people should attend your annual meeting in person or by proxy, I don't think that's enough to say it prohibits a virtual meeting. Okay, because you can have a meeting virtually. And if you have a meeting virtually and you're present at that meeting, you're considered to be present in person. So I don't know what provision the person is referring to, but for me, I think it's got to be real specific that your documents prohibit a virtual meeting. Like, it's got to be black and white. It can't just be the standard provision that says, you know, you should elect your people in person or by proxy. You know, I would take the argument that that's not enough on the other side. You know, but every community is different. Maybe your community does have that. It was very rare for me to see that in the documents I've looked at. So, but you know, it could happen. And if there is a conflict, let's say your bylaws conflict with the law, I say the law trumps. You know, pun not intended, given today's inauguration day. But so, you know, that's, nobody really knows the answer to that. You know, I'd say the law trumps if it's the Nonprofit Act over your bylaws, which means, you know, maybe the meeting is allowed. But I mean, if your documents, you know, expressly prohibit it, well, I mean, that's a different question. I mean, because the act says you're allowed to do it as long as your documents don't prohibit it, right? So if your documents prohibit it, then you can't do it. But then it's like, okay, your question is, well, now we can't have our meeting. We violated the other law about every 15 months. Okay, well, again, my answer is, nobody really knows what will happen in that scenario. I think It depends on the judge you get. And no, the facts and circumstances of the case, and whether what your board tried to do is reasonable. I mean, the argument can be made that, yeah, you're violating the law. You didn't have a meeting within that 15-month time frame. But I guess to me, if it looks like you were trying to stonewall somebody and keep them off the board, that's where you're gonna have a problem. If nobody is really hyper about getting on the board, I don't think it's an issue at all. So I guess my answer to your question is nobody really knows, because nobody's seen a case that challenges the statute versus your bylaws in that scenario if they that the two conflict on a 15-month requirement.
And Greg, can a co-owner claim discrimination if they don't have electronic capabilities to attend a Zoom meeting?
Yeah, that's interesting. I think that is not impossible, but they would have to kind of, outline that claim. How is it discrimination against you for what? Is it disability? Is it race? It's kind of a few steps between the logic there. But to me, that kind of reminds me of, people that don't speak English. Is it discrimination to have your meetings in all English and I don't speak English? It's like, well, no, technically it's not. But if you are using that as a proxy to discriminate against people from different countries, then it could be a discrimination claim based on ethnicity, because you're kind of using the language barrier as a way to discriminate against those people who are of another race. So it's like a couple steps removed, but the logic is there. So could that happen? I mean, yes, but I'd want to see how it ties back to what law are you breaking? What part of the discrimination statute is that tied to? Is it it could be disability, I suppose, if somebody has a disability that prevents them from using technology. Maybe it's an age-related disability, but it can't just be, I'm 80 years old and I don't use computers. No, that wouldn't fly.
And if you didn't have an annual meeting in November of 2020, can an outside meeting be held in July of 2021?
I mean, yeah. I mean, you might be violating the 15th month requirement. It depends on what your bylaws say when your meeting is supposed to be. Because if your bylaws specify a date, then you got to run it from there. If your bylaws don't specify a date, then it's just 15 months between your last meeting. So it depends on what your bylaws say, and then if your bylaws don't say anything, then it's okay, was it 15 months or not? I wouldn't worry too much about if you're a month or two off, who's going to care? I mean, it might not technically comply with the law, but if you have, people know you're going to have the meeting, you're not procrastinating, and maybe you're a month or two late. I don't see that as a problem. I think anybody who sues you in that scenario would be seen as unreasonable, especially if they know that you're going to have the meeting. But yeah, I think outdoor meetings, aside from that, are a great idea, especially in the warmer weather, and it can be done. I think you should strongly consider that as an alternative to not having a meeting.
And then one more question before we move to the next slide. If there are 121 members in the association and quorum is 43 and they only get 10 to 12 people at the annual meeting, so they don't have quorum, what are they supposed to do if this happens at every annual meeting?
Is this a math problem, or like, I'm not very good at math, but so this question also comes up all the time, right, Stacia and Melissa? Do you agree with that?
Yes,
yeah.
We do, Greg.
Thank you, Stacia. Thank you, Melissa. Yeah, quorum. That's a separate question. That's always a problem. I mean, that you're going to have that problem every year, regardless of the pandemic, right? So what can you do? Well, a couple different things. Number one, you can amend your documents to reduce quorum. If your quorum is 35%, you can reduce it. When my amendment projects that I do, it's not uncommon to take it down to 30 or 25%, maybe even 20. If it's an HOA that's big, you could even go lower than that. I have one that has a 10% quorum requirement because they have 400 homes. So number one, reduce your quorum requirement so that it's easier to meet quorum. Number two, again, amend your documents so that you can use different types of methods to meet quorum. Make sure your documents allow you to use proxies and written ballots to meet quorum. Okay, not all documents do. So as long as you make your documents very flexible in that regard, and make it easier to meet quorum, that's another way that you can solve that problem. For some communities, it's always going to be an issue, and you might have to fix your documents, number one. I mean, it also helps to be transparent, to communicate with your community, use newsletters, send out information to keep kind of a dialogue. But it's always going to be a problem. What happens if you don't get quorum is just technically what the law says is the existing board continues until you have a meeting, an association meeting where you do reach quorum. So that's what the law says. So if you have a meeting and you don't get quorum, it's like, all right, what I do actually, because I'm president of my site condominium association in Canton, and we've had this problem for several years. And the way we've addressed it is we will say at the meeting, look, we don't have quorum tonight. So technically we can't have an election, but the alternative to that is we have to reschedule, we have to rent this room again. And does anybody have any objection to us just continuing the meeting, and the existing board members will stay on for the time being? No objections? All right, that matter passes by unanimous consent. We're going to move on. So at least you raise the issue, because it gives people that were there a chance to voice their objection. And that's important to note in the minutes, because then it's like, okay, we told you at the meeting we were going to proceed. Nobody objected. So you can't raise it a year later and try to sue us for not having another meeting and an election. So that's how I would handle it. It's not perfect, but it's like the best solution you have. And the law does say if you don't have quorum, that board stays in place. So they stay in place for another year. If people resign over that time, then the majority of the remaining board members can appoint new members to the board under the bylaws. Usually most bylaws will allow that. All right, can we go on next slide? Because I think I'm behind on the slides. Okay. All right, so reopening facilities, your clubhouse, your pool. So number one, the new liability protections, that's a big difference. That's protection you didn't have. You're still going to have those insurance issues. Insurance didn't cover COVID by and large. I did a whole seminar last year on insurance, and it's on our YouTube channel, so check it out. ZDF Condo and HOA Attorneys, shameless plug. We have a YouTube channel. Check it out. Did it like an hour or two talking about that. So you're still going to have concerns about lack of coverage. Hopefully liability protections will cover some of that. You still got to worry about complying with CDC rules while this pandemic is in play. Even though you have the liability protections, like I said earlier, you got to comply. What are the costs of that? Are you going to have to spend an extra, $1,000 a month to have your pool properly monitored? This was an issue for some clients last year that had pools. And I just said, the costs weren't worth it. We're just going to shut it down for this year. Waivers, I also talked about this in my other seminar that's on our channel. Waivers can help. You can get a waiver from an adult that you can waive negligence claims and have them sign off on that. You just can't waive gross negligence claims or intentional wrongdoing claims. So, if the association was grossly negligent in trying to protect you and failing to protect you, then the waiver is not going to protect you. If you were just regular negligent, run-of-the-mill negligent, the waiver will protect you from being sued. Also, you can't waive a minor's rights. So you can't use waivers to waive claims of children of co-owners. And that's another limitation on waivers. But waivers have some limited utility in this situation. So I definitely get them if you're going to reopen your facilities to the extent that you can, and make sure they're well drafted and not full of holes, like Swiss cheese, like a bad waiver would be. So the board has to make the judgment call in 2021, again, evaluating everything, all these concerns, talking to your professionals. Are the risks, do the risks outweigh the cost type thing, cost benefit analysis of whether or not you should open your facility, your particular community. Next slide.
Greg, is a clubhouse in an association considered a commercial purpose or a residential purpose for the MDHHS orders for contact tracing?
I would say it's residential. I haven't read through it specifically on that question, but that is my guess. There might be a difference if you rent it out to the public. Like if you're just renting it out to co-owners, that's private, but if you rent out to people outside the community, that might make a difference. But I know that opens you up on an ADA claim, American Disabilities Act, that kind of puts you into another realm now that you're open to the public. The question would be, if you're open to the public, that turns it into another type of facility. So, I'm not 100% sure on the answer to that particular question, but that would be my guess. That's something we could look into more, Melissa, Stacia, if you want to. All right, let's talk about, there you go, getting the nod. Pool reopening requirements. What is it going to be this year? I just want to talk specifically about this because this was a big one last year. I had Melissa check into this. She's our pool princess for the office. She wrote a great blog article on our blog about this issue last summer, very detailed. So check it out. Check out the information there. Right now, it doesn't look like there's any change in what was required last year from the major counties, but it's early. Obviously, we're not in pool season yet, so we don't know really what's going to be required at this point. What you see on the slide is kind of what was required last year. You had to have a pre-opening inspection. And that was really the big key of it. The big part of it was to have that inspection. The thing that we do know, the one thing that we do know is that 25% capacity limit, that's in the current MDHHS order. That capacity limit is in there. So that applies as of right now. And of course, the CDC rules regarding outdoor pools or indoor pools, would still apply. So those are generally some of the highlights of the requirements. Again, I suggest check out our blog for more details on that. And I'm sure we'll hit it again later this year when we get close to pool season. Next slide. And this is a little bit more on pools. Washtenaw County, they have like really weird rules, like Washtenaw County tends to have, and Ann Arbor. And it's like they were much more onerous, it seems, than the other counties. Now I remember reading these when they came out, and it was like kind of ridiculous, but it is what it is. Depends on the county you're in. So check out, what county you're in as far as what requirements for reopening you're going to have to comply with. And we have links, by the way, on this slide for all of these counties. Also, at the end of this presentation, I want to point out we do have links for all the other articles and materials we're citing to. So you can use that slide page as a resource on the web to access some of this data for yourselves, some of the forms. Next slide, please. All right, enforcement issues. Can we, should we? Let's say, I told my clients last year, your documents still apply, even though we're in the middle of an emergency. Like it's still, you still have bylaws. You still have to follow them within reason, okay? Like it might make sense to be more lenient on some violations than others at this time. Pick your battles. Don't go after somebody that you've been trying to get for years for having their commercial vehicle in their driveway. Don't go after them as soon as that pandemic is declared. That's what happened last year with one community. It was in the paper. And it's like, why are you doing this now? Why are you going after them now, right now? This is like the worst time you could possibly do this. You're finding these people for having their, their truck and their emergency truck in their driveway. Not a good move. But that being said, at the same time, you can't just waive all your restrictions and just throw everything out the window. You can't do that either. So you got to kind of find a happy medium. Talk to your attorney, talk to your professionals. If your documents are too restrictive and don't give you flexibility on handling these issues, amend your documents, amend your bylaws, or amend your rules and regulations to give you more flexibility as a board in addressing these things. I even do these catastrophic event clauses now. A couple of paragraphs I'll plug into your bylaws to address things like COVID if this happens again. So amend your documents. Next slide, please. So can we, should we? This is really good stuff. I want to point this out. The Community Associations Institute has a lot of great resources. I highly recommend checking out the resources. You can become a member of the Community Associations Institute. They charge a fee, but it's an organization that supports community associations across the country. Our firm is a part of it, and I'm also on the Legislative Action Committee, which I'll talk a little bit about at the end of the presentation. But they have these great policies that you can look at that they've been vetted and thought out by the Board of Trustees for CAI. And so they're like, here's an approach that we recommend that associations take. Okay, and so they have a policy on recreational vehicle and trailer restriction covenants enforcement. during COVID, healthcare and essential workers, and basically saying, we recommend that you recognize them as essential workers, and that, you know, these are extraordinary circumstances, and you should enforce your documents, you know, under the, you know, with that in mind, and consider exceptions where they are warranted. And that's the policy that they suggest adopting. So you can look at what they have on, you know, caionline.org. They have policies for so many different issues, for rentals, for amendments, for reserve studies, reserve accounts. You know, check it out. It can be very useful to your association if you're looking for some background of, you know, how should we approach these issues. The last thing I'll note on this is that, you know, if you're going to make an exception to that owner on one of your rules, you know, tell them that this is a limited exception, and, you know, send a letter to the community explaining this. You know, you're not waiving all your rules. You're just having a temporary policy of XYZ because of COVID, so that they know what's going on and why you made that decision. Next slide, please. All right, almost done. A few more slides, running out of time. Financial impact of COVID. You know, surprisingly enough, there really was not a big effect financially because of COVID on associations. At least there was a survey done, CAI did a survey in May of last year, and most associations said they had not experienced an increase in delinquencies. And that's a little surprising, you would think, because of all the unemployment, that you would see this spike, you know, in a huge manner, but that didn't happen. So I was thinking to myself about this, why is that the case? It's like, well, number one, you got stimulus. So you got unemployment payments coming, the government supporting people. Number two, moratoriums. We can't foreclose certain types of mortgages that are federally backed, you know, and you can't do eviction. So these moratoriums are still in effect, are greatly shutting down foreclosure activity, which protects the real estate market. And I know Melissa was telling me the other day about county by county, how they have different policies on foreclosure sales. You know, some were not doing them, others were. So it's kind of a hodgepodge, but again, they're not doing foreclosures by and large, or we're not. And the market's hot. I mean, prices are up. People have equity in their homes so they can sell them to pay off their liens. So it's a totally different real estate market than what we had in, you know, 06, 07 through 2010. So it's not the same deal. And I don't think you really need to, for the time being, to think about, you know, panicking and thinking we're back to 2009 and 2010, because we're not. Next slide, please. Now that could change, you know, might they spike later this year or next year? Yeah, I think that's certainly possible. Interest rates could rise because of what the government's going to do with stimulus, doing a lot of lending. That's going to, you know, possibly raise interest rates. That could shoot down mortgage activity, shoot down the real estate market. So stimulus is going to end eventually. Foreclosures eventually will resume. So I read this concept in an article recently, the pig and the python phenomenon, which is you have these people that became delinquent, and that's just kind of in like March or April of 2020, and those people are moving through the system, and it's like a big, you know, bunch of people. And once that group of people goes all the way through the system to the end of the delinquency process, then you might see the jump in foreclosures. Pig and a python. So other issues financially for associations, possible increase in insurance premiums. CAI is reporting that 10 to 15% increases in premiums you might see. You might see more spending because people are at home more. So maybe your association is has a higher water bill. Maybe your electric bills are higher. Increased costs of disinfecting and cleaning surfaces. We've already talked about that. You might have that for your association. Cost of doing business, inflation. We might see more inflation. We might see, you know, $15 an hour wage, you know, federal wage mandates. So that might increase your costs. So you might need to adjust your budget, you know, as we go through this year, because again, things are changing on the fly. So could be another crazy year, but you got to just kind of read where we're at and adjust accordingly as a board. Next slide, please.
Well, before we go to the next slide, Greg,
Okay.
I have a question. A unit has been empty for over a year. The person who owned the unit is in jail and isn't going to be getting out. The foreclosures have been put off and the unit owes over $14,000, which is a huge burden to this particular community. Can the association rent out this unit?
Generally, the answer is yes, but you got to have title first in possession. So and I don't know if this is a client of ours, I hope not. I'm just talking generally about this. And so, yes, if you foreclose as an association and want to rent out a property that you've already foreclosed on and got title to, you can, at least on a temporary basis. If there's another mortgage on that property, the mortgage company might foreclose on top of you and take that, and then the person in your unit might sue you. So, you got to be careful when you do it. It is possible to do in general, but it might not be the best thing to do. So you really need to talk to your attorney, shameless plug, and see if there are risks to doing that. If there's another mortgage on the unit, if there's another way to get your money, that would be better. I mean, it's tough right now because if you can't foreclose, and the county is not doing sales. Some of these counties just not doing foreclosure sales for months. So you can't get title. Okay, so if you don't have title, you can't rent it out. Maybe they'll give you some kind of a quitclaim deed that you get, but you said maybe from the estate of the owner if they were alive. If the person's in prison, you can't reach them. That might be impossible. So it's a tough situation. You got to talk to your attorney what the best option is. And the circumstances we're under right now just make it even harder because of the foreclosure moratoriums. So that's another complication we didn't have, before this happened. All right. Where are we at? Oh, privacy and vaccines real quick. I know we're all about done. Just to wrap it up, people have a right to privacy. So you can't ask them if they have a disease, right? So why would you be able to ask them if they've been vaccinated? I don't think you can. I don't think you should be inquiring into people's vaccination status or tracking them. If you start tracking them and then you screw it up, is somebody going to sue you because you screwed up the vaccine tracking? Maybe. So I don't think you should do it. I mean, this is kind of a topic that's only going to become more prevalent as you go through the year because, not everybody can even get the vaccine right now. But I'd say, don't do it. Don't inquire. Don't pry into this. And if you do, you could have possible privacy law violations, or you could be sued for, fair housing issue too. So, if you're that concerned about COVID where you think you need to know everybody's vaccination status for entering the pool, maybe you just don't open your pool. That'd be my advice. Next slide. Takeaways. All right, wrapping it up. We're in a very fluid situation. Circumstances and rules are always changing. Things are different this year than last year. Don't just do what you did last year. Talk to your attorneys, talk to your professionals about whether that's still the right thing to do now. Keep an eye on the vaccine rollout, keep an eye on cases, what the county's saying, what the state is saying, what the federal government's going to say. Now with Biden in there, we can expect some changes there as well. So all this is still changing, and it's just makes your job harder as a board member or a property manager. But that's part of the gig. So keep on top of it. Work within your documents. If your documents are bad and don't let you do stuff, amend your documents or consider adopting rules and regulations to let you do the things you want to do. Be reasonable with people always. Respect their privacy. Maybe you want to add future catastrophic event provisions to your documents. Don't assume insurance is going to protect you on these things. If you have questions about coverage, check with your insurance agent and make good decisions based on the science and the best information available to you and the information provided to you by your qualified professionals. That's all I have, everybody. And we just made it over 1 hour here. So I'll take any final questions and then we'll wrap it up. Any final questions, Melissa, Stacia?
I don't have any right now.
Okay. And then we're going to email people. Go ahead, Stacia.
We're on about a 10-second delay with Facebook Live, so give us just a few seconds.
All right. I do want to mention again, if you want a copy of this PowerPoint, we will email it to you. Just please put your email address in the chat and request a copy, and we'll have Melissa or Stacia will swiftly send you a copy of this presentation. Check out the links of interest at the end of the PowerPoint. Here they are. Lots of great information and resources for your association. And last thing I want to mention is, again, the Community Association Institute. I am a co-chair person of that committee. We have about 14 people on the committee that is made up of attorneys, property managers, and homeowners. and we're trying to make laws change for the better in Michigan. I would, you know, I would really like to get more people involved, and we would appreciate any support you can give the LAC. If you'd like to make a donation, go to the website. That link is on here. Your donation would go towards supporting our activities to make our laws better. You know, we don't even have a statute for HOAs. You know, that would be a good thing to have. We're trying to protect condos and HOAs from being wiped out by the Marketable Record Title Act amendments. So those are just a few of the things that we're working on. And we're working to help associations remove discriminatory covenants from their documents. So all these things, we're working with our lobbyists and legislatures in the Michigan legislature to make new laws, to make better laws for associations. So please check it out. And I humbly request if you could support us, that would really go a long way to achieving our goals and making better laws for everybody in Michigan. And that's all I have to say.
Month, our presentation will be on February 24th, and Ed Zelmansky will be presenting Housing and Essential Civil Right, and that will be on Zoom and Facebook. And we will send you all an invitation and post the actual time on our website. If you have any questions for Mr. Fioritto, you can give him a call at 734-459-0062 or email him at gfiorito@zdfattorneys.com. And if you didn't put your email in chat for the presentation or in the comments for Facebook for the presentation, or if later you decide you want a copy, you can email myself or Stacia.